Okay, I said I had about 5 minutes, and I mean it, to destroy any argument by the Mississippi State Attorney General's office. That's what I'm going to do. What does Article 3 of the Bill of Rights mean? I think I need to give them some schooling on that. I think the state of Mississippi needs some schooling on federal law. I think it's time to deal a crushing, one-and-done blow to that damned good old boy system of law. Article 3 of the Bill of Rights, Section 1. No person shall be deprived of life, liberty, or property without due process of law, nor shall any person be denied the equal protection of the laws. The constitutional requisites under Article 3 existence of standing the plaintiff must personally have. There's 3 different factors here. Number 1, suffered some actual or threatened injury. 2, that injury can fairly be traced to the challenged action of the defendant. And 3, that the injury is likely to be redressed by a favorable decision. 1, 2, 3, hit the nail on the head. What's in justice court right now 100% meets the criteria for removal from justice court to be tried in federal court in the district court for the Northern District of Mississippi. Since day one, I've stayed consistent on deprivation of due process rights and deprivation of equal protection of the laws. I haven't wavered. Call me crazy, I've talked about the same thing. And it's funny, kind of like the story of the tortoise and the hare. My actions may have seemed very much like the hare at times, but really when you get to peeling back the onion, looking underneath the hood, a lot of people are going to find out that they're really quite turtlesque. Prosecutorial misconduct. There's a lot of that going on right now in justice court. This is what's going to hammer them over the head hard. When a conviction is obtained by the presentation of testimony known to the prosecuting authorities to have been perjured, due process is violated. The clause cannot be deemed to be satisfied by mere notice and hearing if a state has contrived a conviction through the pretense of a trial, which in truth is but used as a means of depriving a defendant of liberty through a deliberate deception of the court and jury by the presentation of testimony known to be perjured. Such a contrivance is as inconsistent with the rudimentary demands of justice as is the obtaining of a like result by intimidation. What do you know? 9 charges. You have the recent stuff with Scott Mills, Joey East. Doesn't take a rocket scientist to know that there's a huge abuse of power, a long-time corrupt good old boy system which is trying to use intimidation like they did back in 2017 to cover up wrongdoing of Timmy Pruitt and to hide it with more wrongs and then to try to seal everything up with the covenant to not sue and banishment. 1154 Mooney v. Holohan, 294 U.S. 103. That requirement in safeguarding the liberty of the citizen against deprivation through the action of the state embodies the fundamental conceptions of justice which lie at the base of our civil and political institutions. Hebert v. Louisiana is a requirement that cannot be deemed to be satisfied by mere notice and hearing if a state has contrived a conviction through the pretense of a trial, which in truth is but used as a means of depriving a defendant of liberty through a deliberate deception of court and or jury by the presentation of testimony known to be perjured. Such contrivance by state to procure the conviction and imprisonment of a defendant is an inconsistent with the rudimentary demands of justice, as is the obtaining of a like result by intimidation. Here's the key one. and the action of prosecuting officers on behalf of the state, like that of the administrative officers in the execution of its laws, meaning the Sheriff's Department, the Attorney General's office, those that set laws, that enforce laws, may constitute state action within the purview of the 14th Amendment. That amendment governs any action of a state, whether through its legislature, through its courts, or through its executive or administrative officers. Carter v. Texas, Rogers v. Alabama, Chicago, Burlington, and Quincy v. Chicago. The principle enunciated has required state officials to controvert allegations that knowingly false testimony had been used to convict, and has upset convictions found to have been so procured. Extending the principle, the court in Miller v. Pate overturned a conviction obtained after the prosecution had represented to the jury that a pair of men's shorts found near the scene of a sex attack belonged to the defendant, and that they were stained with blood. The defendant showed in a habeas corpus proceeding that no evidence connected him with the shorts, and furthermore, that the shorts were not, in fact, blood-stained. Let's draw the similarity here. There was not, in fact, an AR-15 back in 2017, and that the prosecution had known these facts all along. Nafu v. Illinois, Alcorta v. Texas. In the former case, the principal prosecution witness was defendant's accomplice, and he testified that he had received no promise of consideration in return for his testimony. In fact, the prosecutor had promised him consideration, but did nothing to correct the false testimony. See Giglio v. United States. In the latter case involving a husband's killing of his wife because of her infidelity, a prosecution witness testified at the habeas corpus hearing that he told the prosecutor that he had been intimate with the woman, but that the prosecutor had told him to volunteer nothing of it, so that at trial he had testified his relationship with the woman was wholly casual. In both cases, the court deemed it irrelevant that the false testimony had gone only to the credibility of the witness rather than to the defendant's guilt. What if the prosecution should become aware of the perjury of a prosecution witness following the trial? More than 30 years ago, this court held that the 14th Amendment cannot tolerate a state criminal conviction obtained by the knowing use of false evidence. Mooney v. Holohan. There's been no deviation from that established principle. Napu v. People of the State of Illinois. Powell v. State of Kansas. Alcorta v. State of Texas. There can be no retreat from that principle here. This line of reasoning has even resulted in the disclosure to the defense of information not relied upon by the prosecution during trial. In Brady v. Maryland, the court held that the suppression by the prosecution of evidence favorable to the accused upon request violates due process where the evidence is material either to guilt or to punishment, irrespective of the good faith or bad faith of the prosecution. In that case, the prosecution had suppressed an extrajudicial confession of defendant's accomplice that he had actually committed the murder. The heart of the holding in Brady is the prosecution's suppression of evidence in the face of a defense production request where the evidence is favorable to the accused and is material either to guilt or to punishment. I've asked for things over and over and over again. They've gone ignored, but they expect me to go to trial. Important then are A, suppression by the prosecution after request by the defense. B, the evidence's favorable character for the defense. and C, the materiality of the evidence. In United States v. Augers, the court summarized and somewhat expanded the prosecutor's obligation to disclose to the defense exculpatory evidence in his possession, even in the absence of a request or upon general request by defendant. First, as noted, if the prosecutor knew or should have known that testimony given to the trial was perjured, the conviction must be set aside if there's any reasonable likelihood that the false testimony could have affected the judgment of the jury. Second, as established in Brady, if the defense specifically requested certain evidence and the prosecutor withheld it, the conviction must be set aside if the suppressed evidence might have affected the outcome of the trial. Third, the new law created in Augers. If the defense did not make a request at all, or simply asked for all Brady material, or for anything exculpatory, a duty resides in the prosecution to reveal to the defense obvious exculpatory evidence. Under this third prong, if the prosecutor did not reveal the relevant information, reversal of a conviction may be required, but only if the undisclosed evidence creates a reasonable doubt as to the defendant's guilt. I mean, just bam, 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 bam. Corrective process, appeals, and other remedies. A state is not free, however, to have no corrective process in which defendants may pursue remedy for federal constitutional violations. In Frank v. Mangum, the court asserted that a conviction obtained in a mob-dominated trial was contrary to due process. If the state supplying no corrective process carries into execution a judgment based upon a verdict thus produced by mob domination. This has been mob domination in Lafayette County since day one. It's still there. It's still going on. I can't get an attorney. It's because it's a mob of influence. The state deprives the accused of his life or liberty without due process of law. Some form of corrective process when the convicted defendant alleges a federal constitutional violation. I've alleged numerous. Contravenes the 14th Amendment, so I have standing, and the court has held that to burden this process, such as by limiting the right to petition for habeas corpus, is to deny the convicted defendant his constitutional rights. Habeas corpus went ignored. The mode by which the federal constitutional rights are to be vindicated after conviction is for the government concerned to determine. Wide discretion must be left to the states for the manner of adjudicating a claim that a conviction is unconstitutional. States are free to devise their own systems of review in criminal causes. A state may decide whether to have direct appeals in such cases, and if so, under what circumstances. In respecting the duty laid upon them, states have a wide choice of remedies. A state may provide that the protection of the rights granted under the federal Constitution be sought through writ of habeas corpus or coram nobis. May use each of these ancient writs in its common law scope, or it may put them to new uses, or it may afford remedy by a simple motion brought either in the court of original conviction or at the place of detention. Habeas corpus. So long as the rights under the United States Constitution may be pursued, it is for a state and not this court to define the mode by which they may be vindicated. So not only are they refusing me vindication where they have to, but they're persecuting me on 9 additional charges, expecting me to go to trial in lieu of a demand for a jury trial. You have the judge that was originally linked in with everything that's picking the damn Justice Court judge. You have discovery being withheld, refused, key discovery necessary for trial. There are so many due process rights. Lafayette County has gone on tilt. They said, we've denied most of them to him. We've gone this far. And damn it, we're going to deprive every single bit of his due process rights here going forward. No right to trial by jury. No right to evidence. Didn't give him a preliminary hearing.
False imprisonment.
Multiple violations of the RICO Act. Child exploitation. Human trafficking. Extortion. And so many damn counts of conspiracy. Joe East wants to always joke, always laugh and say that it's another Matt Reardon conspiracy. I just let him laugh. He clearly doesn't know the legal definition of what conspiracy is, which is basically a plot. Conspiracy is a conjured up plan, a plot between 2 or more people. And when one of those 2 people just happens to be an officer working under color of law, it aggravates it to a federal level. I have 100% standing. Should the state continue going down the path that it's going down, refusing to afford some type of redress to the situation, then the federal courts are going to jump in.
I have no problem involving them. It's where this belongs anyways.
Plenty of case law backing it up. And this is precedence that they've said time and time again. Not even the first case can be gone against. It's that crucial, that important. See you at the finish line.